Good morning. Are you Brianna Jones? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Jones, in cause number 25, DCCR 1909, you're charged with a third-degree felony offense of obstruction or retaliation from November 16th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Jones is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Smith, what's the state's position with regard to reduction of bond based on the plea?
No, I'm opposed, Judge.
So, Ms. Jones, what I'm going to do, based on the nature of your plea, is reduce your bond to $1,000. I'm going to make that a personal bond, which means you're not going to have to pay any money. You're just going to get released today. But there's some very important things about that, okay? First is that the very first thing you do is go straight to the probation department so they can start that process to do that report for me. If you don't do that and you don't make that appointment and then follow through with it, you run the risk of me not accepting this plea agreement. Things could be much worse. Do you understand? Second is, if you are arrested for anything between now and when you come back for sentencing, obviously things could be much worse. You understand? And then the last thing is that you're not required to pay any money, but if you don't show up for court, then they can go after you for that $1,000. And obviously, if you don't show up, I won't go along with this plea agreement. Okay. All right. We'll see you back at sentencing. You'll get some paperwork today from probation. It'll tell you where to go and everything. So make sure you do that when you get out.
Thank you.
Yes, sir. Yes, ma'am. What's that?
Judge, my objection didn't change.
Okay. Mr. Macon, you have Calvin Hawkins.
Yes, Your Honor. It's a motion to drop.
Is that this?
Yes, ma'am.
Thank you.
I believe he's set on the trial docket.
Okay.
Yeah. I'm wonderful.
What,
Hold on, I'm looking, Judge.
how soon, I guess? Good morning. Are you Calvin Hawkins?
Yes, ma'am.
And Mr. Hawkins, in cause number 24, DCCR 1160, you're charged with unlawful possession of a firearm by a felon. You've hired Mr. Macon, and Mr. Macon has filed a motion to withdraw as your attorney. Do you intend to hire another attorney?
No, I'm indigent. I need a court appointment.
Okay.
I had wrote you and him a letter stating that I was firing for misconduct and misrepresentation.
I got your letter, and I'll allow him to, Mr. Macon, I'll grant your motion to to withdraw.
Thank you.
And so what we'll do, Mr. Hawkins, is we will appoint someone to represent you. It's important that you understand, it is very likely that the information they're going to relay to you is going to be very similar or the same as to what Mr. Macon has. Mr. Coleman will remain as the attorney for the state, and so whatever offer is, it is, whatever evidence there is, there is. None of that's going to change when you get a new attorney. I just want to make sure you understand, we're not going to go through attorneys. I've already allowed him to withdraw. I'm going to get you a new one, but you need to pay attention, listen, go through the evidence and discovery with that attorney. Hold on. And then we'll see where we want to get with your case, and we'll set it for an announcement, okay? But we'll get somebody appointed today. They should be out to see you very soon, okay?
I wasn't getting anything.
That's okay. I got it. It's done.
And there wasn't a rejection, Judge, so it's not on the
Okay, and you can just put whoever it,
on the wheel or?
no. Mhm.
Thank you, Your Honor.
Thank you. Mr. Lewis on Brewer, Janineia Brewer.
His mother fired me.
Morning.
But Judge, we're just waiting. But I know how to go to this phone. It's public. Anyway.
Yeah. Oh. Good morning. Are you Janineia Brewer?
Yes.
And Mr. Lewis, will your client waive the formal reading of the indictment?
She does.
Ms. Brewer, in clause number 23-41322, you're charged with a state jail felony offense of theft from September 25th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up.
Yes, ma'am.
And so I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, also $500 restitution, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Brewer is not competent?
No, Judge.
And because, is there any history or anything?
No, Your Honor, this offense is a few years old. She was 17 at the time. I show no history as of the time of this offense, and I don't see anything in our system showing that she's been in trouble since. It just took them a while, I guess, to pick her up. I don't know what's happened in the intervening years.
Okay. Any issue with waiving the pre-sentence report
No,
since
Your
it's a
Honor.
state jail? Okay. So, Ms. Brewer, what I'm going to do is waive the pre-sentence report.
Actually, maybe we could ask her if there's,
Yeah.
just to be
So
sure.
you're
I
under-
don't have a record of anything.
So you're under oath right now. You took an oath over there. Have you been in any trouble since 2022?
No, ma'am.
Okay. Where have you been living?
Right now, I stay in Beaumont.
In Beaumont, but have you been gone for a while somewhere else?
It's in Vegas.
You went to Las Vegas?
Yes.
Okay, all right. So what I'm going to do is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay that $500 fine, and you're also ordered to pay the $500 in restitution, and follow any and all other rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. It sounds like this was something that happened when you were very young and out of character for you, so this shouldn't be an issue. At the end of the probation period, if you complete it successfully, the case is actually dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for between 6 months and up to 2 years. Do you understand? I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. Also, Ms. Brewer, it's important you know, I sign every day early terminations for people off of probation. So if you get in there, get everything paid off early, do whatever community service you need to, follow all of the rules, there's no reason to expect that you would have to do those whole 5 years, but that's going to be up to you to get it all done right. Okay? Good luck to you, ma'am. Probation will talk to you before you leave the courtroom today and give you your instructions for when you're released. All right. Yes, ma'am. Eric Seagris, Mr. Lewis.
Yes, ma'am.
Say, are you Eric Seagris Jr.?
Yes, ma'am.
And this is cause number 25 DCCR 1836. Mr. Seagris is charged with burglary of a habitation. And what is the announcement?
Judge, I've talked to Mr. Smith about this. I think this is one they may need to reach out and complain it. I think she recently came to their office, so I think we need to get a little more clarification before we proceed. So I
Okay.
think we may need a week or two.
Okay.
To do that.
There was some communication with one of our investigators, and I was out last week, so I haven't.
So I'm just going to do 2 weeks since Mr. Seagris is in custody. So if anything changes, we'll know quick. We're just going to do a short recess so that the assistant district attorney can talk to the complaining witness and see if that changes anything about any offers or the status of the case. Okay? So we'll see you back in 2 weeks.
Yes, ma'am.
You can go back with the bailiff. Mr. Parker, let's see, Maria Gutierrez.
Expand the judge.
And Mr. Zapata's here. You're already under oath. Thank you, sir. Good morning, ma'am. Are you Maria Gutierrez?
Maria Gutierrez? Yes.
And Mr. Parker, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Gutierrez, in cause number 25 DCCR 1120, you're charged with the state jail felony offense of theft of property from May 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker and the translator?
Yes.
Do you fully understand those documents?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Sí, sí, eso. O la pueden negar en el futuro. Yes.
State tenders number
No
one.
objection.
It's admitted. Is there any evidence that Ms. Gutierrez is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily.
El juez decide cuál es el acuerdo que tiene.
Find that you're mentally competent and understand the nature and the consequences of your plea.
Mentalmente,
Find sufficient evidence to find you guilty,
que haya suficiente evidencia para encontrar a su padre.
and at this time find you guilty of theft of property.
Y le declara culpable de robo de propiedad.
Sentence you in accordance with your agreement
Que le va a dar su de acuerdo
to a term of 18 months in the state jail prison.
18 meses en la cárcel.
You will receive credit on that sentence
Va a recibir crédito
for any time that you've been in custody that the law gives you the right to receive.
que usted está en custodia.
I'm handing you the trial court certification
Este documento es un certificación
that shows that this was an agreement that I followed, and so you waived your right to appeal.
que enseña que es un acuerdo que el juez así.
I also handed you an admonishment regarding your ineligibility to possess a firearm or ammunition.
Que ustedes eligen para tener una arma.
Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition.
Entonces, el Estado de Texas, por el culpable no puede tener arma.
The admonishment is in Spanish. You should read it carefully.
Está en español.
If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, you should ask Mr. Parker.
No puede pedir el señor juez. Arma de juego como un tipo de arma o pistola. Sí, no puede tener usted.
All right. Thank you, ma'am. Good luck to you. You can go back with the bailiff.
Es todo, gracias.
Pero 18 meses derecho,
Crédito. Sí.
voy a venir a notar el
¿Perdón?
voy a venir otra vez
No, ya va a empezar.
a sacar.
Sí. ¿Es for her? Yes. Okay, eso es para usted.
Thank you. Thanks, Ron. Jacobe and Dorsey. Okay, so you're Jacobe and Dorsey. All right, and was there any additional negotiations?
Just for the record, Judge, I've asked him without talking to Mr. Coleman if he would take the 20 years if it wasn't stacked. He indicated that he wouldn't. Mr. Coleman kind of it implied that he may offer that, so I didn't know if you want to change that, but it hasn't really been an offer of that, but.
All right, so Mr. Dorsey, it sounds like even if it was a sentence that would run concurrently at the same time as that 30-year sentence that you're serving now, or could be serving if the appeal is affirmed, that you don't want to take any offer or a plea on this case. Is that correct? All right, then what I'll do is get your case set for trial. Mr. Dorsey, Mr. Parker has been appointed to you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, we'll get that done. Mr. Parker, you're released, and Mr. Dorsey, someone will be appointed today. They should be out to see you very soon to begin preparation for trial. And do y'all know how long the appeal has been pending? Does anyone, do y'all have any idea?
It's been a couple months at least.
Okay. It was out of the other court though, right?
Yes, ma'am.
Okay, all right, so if y'all get any information on that, if you'll just let me know, it'd be nice to have that potentially by the time we go to trial, but we'll see. All right, thank you, sir. You can go back with the bailiff.
And I think that Rep Price hired on that David Brewer.
Yeah, and you have Patrick Trahan?
It's getting evaluated.
Are you filing something?
I will, yeah. He's one that was normal, then just went crazy yesterday.
Oh, we need to reset him?
Yes, ma'am.
Okay, we're gonna reset Patrick Trahan for an evaluation. Yes,
On Dorsey, the representative next door on the revocation, it was an MTRP revocation. And
Right.
it got 30 years.
Yeah,
And then
that's-
just filed a bill.
yeah, that's what they said. Thank you.
Aggravated robbery.
Let's see.
It's the case where the guy got killed out in Gutierrez.
Mr. Kimler on Naomi Kid. So I have that sentencing, but why'd y'all do new paperwork? I don't understand.
This is a I just took count one.
I mean, he's already pled on 4, 5, 8, 9, and 13.
Okay,
Pled true before, and we got an updated pre-sentence report. And he wants to change his plea
it's fine,
on,
4, 5, whichever he's pled true to.
what, am I on Naomi Kid?
Yes,
Okay, well, this is one we had lost our file, so I had to get it recreated, so I just have the motion. Was there it looks like it was an amended motion? And somehow that file got lost, so I'm behind.
All right, so
That's
what we,
fine, if he's already pled, Judge, we'll just go with those counts.
so previously, Mr. Kidd was in court, entered pleas of true in a motion to revoke or a motion to adjudicate, and pled true to, again, counts 4, 5, 8, 9, and 13. At that time, it was unagreed.
he subsequently received 117 months in the federal system, Your Honor, and we've reached an agreement.
Okay. So he has already been sentenced in the federal system to 117 months.
And it will run consecutively to this.
Okay.
That's why we're doing the low offer, just to clear this case, Judge.
And that's by court order.
Okay.
I've got a copy of that, Judge, if you need to see it.
So he's on, I understand what y'all are, I understand what y'all are trying to do. However, I don't know that just getting rid of the case is what I think is appropriate. If he's on probation for robbery, placed on probation November 16th of 2022, and has now been sentenced, which means he either pled guilty or a jury found him guilty of new offenses while on this probation of Hobbs Act robbery, brandishing a firearm in a crime of violence, possession of a controlled substance with intent to distribute, and possession of a firearm in furtherance of a drug trafficking crime.
Your Honor, I'm not sure the offense dates of all that. They may predate him being placed on probation.
They dismissed all the other charges.
What did you get 117 months on?
For the brandishing and the rob. The other charge was dismissed.
So the brandishing a firearm in a crime of violence. So brandishing a firearm in the robbery, but they just,
It's two charges. It's the same charge, but it's just two different charges. It's the same crime, just two different charges.
so the Hobbs Act robbery and the brandishing a firearm. Okay, and you got 117 months for those. Okay, I want to know offense date.
What was the offense? When would that arrest have been committed?
Do you have that?
I've got a judgment, but it says offense ended 2/19 of 25. I don't know if that means that was the offense date or if that was the date that he pled.
2/19 of 25 is the offense date, and I have he was taken into custody on February 25th of 25.
Does that sound right when it was committed?
February of last year is when you did it.
That's why I came to jail.
But when did you,
Like January.
okay. So after you were already on this probation, this didn't happen a long time ago before you got this probation. You were on my, I want to make sure, you were on my probation
Just answer it. Well,
and you committed the new office. I'm just trying to get the timeline. Correct, okay. Then I understand how,
The feds had already picked it up, you know, picked up the other charges.
you started my probation in 2022.
Listen, correct.
My question is, did the new robbery, the federal robbery, happen before 2022?
No, I was
No.
already on probation.
Right, okay. So I understand the moving of the case. He's already pled true to counts 4, 5, 8, 9, and 13. I think with the judgment, obviously, and the state could easily prove up the new, at least part of the new offense. I'm not going to accept an agreement of 2 years. I don't think that is appropriate. I understand that it runs consecutively, but it sounds to me like somebody who's on robbery, who commits another robbery, needs a little more time. So, I mean, 117 months is,
It's like almost 10 years.
yeah.
Do you want to get an updated pre-sentence?
I already
report?
did. I'm ready to sentence
Wanting
him today.
To reflect the federal, reflect the
I've already
facts of the
got it.
federal case?
I mean, no, I've already got an updated pre-sentence report. Y'all have got a judgment saying he's got 117 months.
I didn't know if the court wanted to know the facts of the underlying federal charges.
If you want to tell me them in
I
a
don't-
hearing today,
All right.
here's the thing, it's already was unagreed. We're going forward unagreed. I'm deleting this paperwork. Let's go forward. I'll make a decision today on sentencing. And so let's start with Mr. Smith. Well, first, have you both had an opportunity to review that updated report?
Yes, sir.
I have not, Judge, but
You want to?
I.
I'll hold the case. Go ahead. You good? Okay.
I think, okay.
Do you, so with regard to counts, let me look and see which count it actually was. It looks like, I mean, hold on. Okay. So it looks like after he pled on the, when we were here before, he pled on a first amended motion to revoke unadjudicated probation. And since then, another administrative hearing was filed. There is a second amended motion to revoke unadjudicated probation. Let's see what that included that this one did not. For the discussion and testimony today with regard to the fact that he has received 117 months on a federal offense of some combination of either Hobbs Act robbery or brandishing a firearm in a crime of violence, same offense.
Both, was convicted on both of those. He received 33 months on count 1 and 84 months on count 2. So I would assume the 33 months would be the brandishing of firearm and the 84 months would have been the Hobbs Act robbery.
The firearm case would have been stacked.
And those are running
Those are stacked
stacked.
on top of each other and stacked on top of whatever the state gives.
Whatever this, so they knew over there that this was pending and that judge already made the decision that this would run consecutively.
I spoke to his defense attorney in the federal system,
Okay.
Gary Bono, and I believe he said they deviated up based on the fact that this case was already pending.
Okay.
The pardon.
It was taken into consideration in his federal sentence, and they went above what the guidelines said.
So there was an upward departure then because of the case being committed while he was on probation.
Sounds like it.
I believe so.
Okay, Mr. Kimler, you may go forward with argument for sentencing.
Well, Your Honor, I suppose the salient factor here in sentencing is the commission of the charges that led to him being indicted federally. And I understand the court's reluctance to accept what amounts to a de minimis sentence on the state charges because of the 117-month state charges. I suppose I would simply observe if we've just determined that there was an upward departure in the sentencing guidelines in the federal system that was predicated on the pendency of these, them committing this federal charges while on state probation for these charges. I know the court's probably inclined to go above the 2-year recommendation, but what the court stated previously, I would simply observe that he already has been somewhat sanctioned in the sentencing determination of the federal system because of the status on probation here in state court. These are going to run consecutively. And you may have gotten less time federally, but for the existence of this probation. So I would just ask the court consider that in determining what the proper sentence is in this revocation.
Thank you, Mr. Kimler. Mr. Smith?
Judge, I have quoted from it. I guess I would offer into evidence a copy, certified copy of the federal judgment, which would allow the court to then find counts 14 and 15, the second amended motion true.
Well, we didn't go through the second amended, so let me see. The first amended actually has the robbery.
That includes everything up through 13, so then the second amended was 14, 15, 16, and 17.
I have no objection to it being considered, the judgment being considered for sentencing purposes
Okay.
here, obviously.
And the first amended actually on count 11,
I believe
The
those were
allegation
the
is-
state charges, the same thing that were not filed with the state, but were picked up by the feds. And that's what
okay,
he was
but it's the
sentenced
same offense, the
Same
robbery,
offenses.
February
Just
19th.
We amended the second time, we included the
Okay.
federal
Same
charges.
factual predicate.
No objection to states one.
No objection.
All right, it's admitted. Anything else? Argument or
No,
thoughts?
state leaves it up to the court in this case.
So what I'm looking at is that there was also, and can't tell what happened with it, back in 2024, there was an unlawful carrying of a weapon by a felon.
They never moved forward on it because technically he was on deferred.
Deferred.
So he was not considered a felon. So they never, that was the original charge that was alleged in the original administrative hearing.
Okay.
But the DA ended up never filing on it. The subsequent charges are federal. and
Gotcha.
That's why they're in the second.
So there was at least an instance back in March of 2024 where the defendant was arrested and in possession of a firearm, but because he was not convicted, it was not filed.
Correct.
So we had that. Administrative hearing was held. He already had completed both tracks of ISF and a motion was filed. And then he was absconder. And while he was absconding, picked up the new federal charges.
Yes.
Okay. All right. Anything else? Anything else?
Is that accurate? Nothing else.
Okay. So then at this time, I am going to find, based on the evidence presented today, count 11 true in the first amended, which is the robbery. It's still the same offense, even though it was federal or county. It was committed here in Jefferson County on February 19th of 2025. Everyone's agreed to that. So I am finding count 11 true. And at this time, Mr. Kidd, I'm going to find sufficient evidence based on finding count 11 true, as well as your pleas of true to counts 4, 5, 8, 9, and 13 to find you guilty of the offense of robbery. I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This was not an agreement, so you do have some rights to appeal. I'm going to hand you that certification, if y'all will please sign it, Mr.
Yes, ma'am.
Kimler, and give him that bottom copy. Also, I'm going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. You need to sign that so you can get a copy of it, saying that you received a copy of that. Thank you. And did you, would you mark this, Philip, please? Thanks. So that would be 2. Yes, states 2, please.
And there's the final decision. 7 years in the Texas Department of Corrections. The judge rejects the proposed 2-year resolution and instead sentences Mr. Kid based on the violations and evidence presented in court. Because this was not an agreed sentence, the judge also explains that he retains certain appeal rights. This hearing shows just how much timing matters in a probation case. When a new serious offense happens while someone is already on probation, the consequences can become much more severe.